Good morning or afternoon, everybody. Welcome to the first of a three-part series on the state of mass incarceration in the United States. My name is JoEllyn Goodman, and I am the chair of the Decarceration Committee of the National Association of Criminal Defense Lawyers. We bring you this important and timely series as we join allies across the nation in recognizing the injustice of 50 years of mass incarceration. These engage and exchange webinars, as Vanessa mentioned, are interactive discussions with the nation's leading authorities on the issues at the heart of the problem. And first among them is the shocking truth about solitary confinement in our nation's jails and prisons. Today, we are fortunate to have as our guest the one person I believe is our nation's foremost authority on this subject, Professor Judith Resnik. Professor Resnik is a professor of law at Yale Law School. She founded Yale's Arthur Lyman Center for Public Interest Law. And since its founding, under her direction, more than 170 graduates of Yale Law School have held Lyman fellowships. It's astounding. She's a celebrated and prolific author and editor and received numerous awards and accolades from the highest levels of academia and the legal profession, including, just to name a couple, her election as a fellow of the American Academy of Arts and Sciences, and her selection as Outstanding Scholar of the Year by the American Bar Foundation. Recently, however, under her direction, the Lyman Center joined with the organization of the directors of all U.S. prisons, now called the Correctional Leaders Association, to study and produce a series of in-depth reports on solitary confinement. For a practice cloaked in secrecy, the report is an unprecedented revelation. Our host today and facilitator is my friend and colleague, JoEllyn Jones. JoEllyn is a criminal defense attorney and founding partner at Jones and Ortiz in the state of New Jersey. She is an active bar leader in her state of New Jersey and nationally. JoEllyn also is co-chair of NACDL's Diversity Committee and an active member of our Decarceration Committee. I look forward very much to today's discussion. JoEllyn, take it away.
Hi, thank you everybody for joining us this afternoon. And thank you again, Judith Resnik, for coming and sharing your knowledge with NACDL and everybody else who's logged in on this important issue of solitary confinement. It's a timely conversation. It's a conversation that I think so far has been silenced. A lot of people don't want to think about it, or they ignore, or they try to justify issues of solitary confinement. So we are definitely honored to have you here. And we're going to start off our conversation with you just giving us some background information, and you have prepared a PowerPoint for us today. So I'm going to let you take the stage.
Well, first of all, thank you. And it's good to join you. I have many former students and colleagues in your ranks, and I'm glad to participate in any way to be helpful. If you turn to the next slide, I'm going to just run through a little bit about the legal regime currently governing the thing called punishment, both in terms of sentences, but mostly my focus is actually on punishment in incarceration as well. And so basically, before anything, this was mostly an unstructured world until people who were incarcerated and criminally charged insisted that law needed to help them. So first off, thanks to the very brave people who moved forward to make claims on the US Constitution and largely succeeded in one respect, in that the Constitution, which was said to have which states insisted had no application to them, came to be read, as they said, as prisoners insisted, incarcerated individuals, to be applicable in some form or fashion. And so part of this is what we who do law, what has law done and what could law do more? So if we just start with just a straight sort of doctrinal approach, the US Supreme Court has developed the idea, born in the Enlightenment 300 years ago, that punishment should not just be terrorizing, but have utilities or purposes. And you get this phrase, penological justification. Then you actually get a list or a grab bag of a ton of stuff that can be a legitimate penological justification, incapacitation, retribution, deterrence, reform or rehabilitation, institutional safety, cost reduction. The set is intention with each other, it's capacious. Notice not here in terms of purpose, in terms of the discussion, are concerns about the equality and dignity of individuals who are subject to punishment, about the role of keeping a community whole and healthy through restoration and harm reduction. So there, we could add to this list many other purposes that we would want a criminal legal system to have, were we to call it a criminal legal justice system, but we aren't there yet. So if you get to the next slide, just to give you a little bit more texture here, early on, more than a century ago, unnecessary cruelty came to be understood as outside the bounds of the Eighth Amendment. Remember, the earlier cases are just about federal punishments till the 1960s. So then you also have the idea of proportionality, something that's not unusual in its character. Then you start moving to the second half of the 20th century in a famous decision by Earl Warren, the Chief Justice. The discussion is evolving standards of decency. Please, of course, those of you who function inside the legal courts today, note that that is an interpretation that talks about a living and dynamic constitution, as compared to some members of the US Supreme Court who say they're only interested in what it would have meant in the 1790s as they understand those words to have been meant then. So just going on, the idea of obviously race discrimination, arbitrary indiscrimination comes in the death cases. And in the next slides, you'll see that now we're moving both inside prison in the Estelle v. Gamble, why is there health care in prison? Deliberate indifference to known medical serious needs is a violation of the Eighth Amendment as unnecessary and wanton pain. And then most recently in 2019, when talking about how the excessive fines clause of the Eighth Amendment applies to states, which was a move that had not been made before then in a case called Timms, Justice Thomas, concurring, picked up old English language that it was an illicit purpose to try to cause the ruin of the criminal. And so just sit for a moment, because there's in work that I have written and am writing, the idea of developing an anti-ruination principle, which is my view of how we should read what a constitution that recognizes all individuals as equals needs to include. It isn't licit for the government to set out to ruin you. And you hear this in the context of economic ruin. Of course, I think it should be much broader. So before World War II, there were many people really worried about how awful prisons were. But their arguments were rarely grounded on the idea that prisoners were rights bearers, but more that the state should take care of people better. In the wake of the Holocaust and the civil rights movement in the United States, the revolution of prisoners' rights came into being. In 1955, the United Nations promulgated standards calling for the respect of the dignity of prisoners and their liberty. And then in the 1960s, famously, the US Supreme Court started taking up the issue. And if you get to the next slide, the first ever class action involving prison conditions is a case called Washington. It was called in the trial level Washington, not as in George Washington versus Robert E. Lee, but named that way by the ACLU lawyers, Caleb Washington versus Frank Lee, who was head of the Alabama prison system. And his prison system operated under state statutes that said Black and white people couldn't be chained together or sleep together. When arguing in the US Supreme Court, a great federal district court judge, Frank Johnson, for a 3-judge panel, held that statute as unconstitutional. Alabama stood up in the Supreme Court and said prisoners have no claim to make that equality claim in 1967. When they made that argument, the first non-white member of the US Supreme Court, Thurgood Marshall, was for the first month sitting on the bench. And so the US Supreme Court affirmed the idea that Alabama's statute was an unconstitutional violation of the Equal Protection Clause to have segregated prisons. But what is painful about this first case is that there's a concurrence. Marshall tried to, I know from private papers, you can read the backdrop, but the concurrence that issues talks about how prison authorities have the right, acting in good faith and in particularized circumstances, to take into account racial tensions in maintaining security, discipline, and good order in prisons and jails. And security, discipline, and good order in prisons and jails moves in 1968 till now as part of what the court always iterates, even as it is announcing the rights basis for people who are in detention and incarcerated. And that basic discount for prisons remains a capacious claim. And I should just add that it's a poignant argument to be making, because federal data analyzed by the Prison Policy Institute, the Sentencing Institutes, tell us that you are 2.5 times more likely as of 2020 to be a victim of homicide while you're incarcerated than when you're on the streets. So this idea that the prisons are places of security, discipline, and good order, prisons and jails, is not an empirical fact. And the question of how you make it to be in any way a safer environment is a huge challenge we all face. If you go to the next, and now I'm going to hone in on solitary confinement. This is a description from 2005 of the US Supreme Court's unanimous decision in a case called Wilkinson v. Austin. And as you are looking at it, this is a description of what solitary is. 7 by 14 feet, 23 hours a day, light on all the time, sensory deprivation, almost all human contact, indefinite. One might think that the next sentence would be, this is impermissible, but no, turn the page, and you'll see that the next sentence is, this may be necessary, said the court, the harsh conditions of Supermax necessary and appropriate in light of danger. It's a very depressing description of also, and of a misunderstanding. And those of you will know that in 2015, Justice Kennedy, in a concurrence, said, wait a minute, it's really a terrible thing, and we really have to stop thinking about stopping it. So this is a decade earlier than he shifts his view substantially. But he talks about it as the only option, but then he goes on, and this is important. The unanimous court, if you turn the page again, says that as a matter of 14th Amendment liberty, that awfulness and degradation and isolation of solitary confinement means that you have some due process because it's atypical and a significant hardship. It's not ordinary. Hallelujah, it's not ordinary. Sadly, it's all too commonplace. And therefore, given duration, given disqualification for parole, given the lack of engagement, you do get a bit of procedural protection before you are put into isolation under this decision. And so, and I saw that JoEllyn put into the chat, with a wonderful group of law students, I went and we looked at hundreds and hundreds of cases about what's atypical and significant, why the radical movement, limit on movement of human beings isn't seen as atypical without anything else is completely puzzling to me. And so, but under this atypical and significant, there are many, many claims to both procedural protection, and sometimes there are Eighth Amendment claims that says we now know so much, and there's such a sad, big body of literature on how harmful it is that it's deliberately indifferent to known medical needs. So there's cases that are both Eighth Amendment substantive due process and or Eighth Amendment cases, as well as procedural due process. If you turn the next page, we get to what made me, I am horrified by the radical intrusion on human beings of solitary confinement. And I wanted to try to understand both more about it and how collectively we could all work on stopping it. So it's an organization of directors of people who run all the state and federal prison systems, which was called Association of State Correctional Administrators and is now called Correctional Leaders Association. And we started doing research with them. First, we wanted to find out how you visit people in prison. All of you who go to prisons know it's hard to do, lawyer or not lawyer. Then we wanted to try to get the formal policies on what ADSEG, administrative isolation. What were the rules across 50 states? It was very sad to spend 3 days reading them. And then we tried to do empirical work by asking each prison system, tell us how many people are in either ADSEG or solitary, or now it's often called restrictive housing. And so we have a series of reports that are some are listed there. If you turn now, the method was to send out questionnaires. And I want to stress and stress again, we asked the people who run prisons, how many people are in these conditions? We did not empirically verify it. We didn't do spot checks. We just said, you who are in control of this number of people, how many of them on average are for 22 hours or more, for 15 or more days in? And we asked a huge slew of questions a repeated number of times. And when you get to the next page, of course, I want to underscore that we used a definition that comes from the UN 2015 Nelson Mandela rules. 15 days or more, they call prolonged solitary confinement, and they call it torture, degrading treatment. We are not saying that people who are in cells for 24 hours are not in solitary confinement. We were just trying to get a grid across the country to capture it. And I can tell you it was labor intensive with that grid. But of course, we are hoping, and we know that there are other groups that are doing more research in this area too, and they will get different numbers. We only looked at prisons, we didn't look at jails. There's a whole host of caveats. If you turn the page again, what you'll find is, here we go. So first of all, not everybody answers. Second of all, not everybody answers all the questions. Third, they aren't the whole prison population. So what I can tell you as of July of 2021 is about 1.2 million people as told to us, if you turn the page. And then there's, I think, a number of people, and you can see something about the population that is there. So we know only about more than 730,000 people. And of that group, about 3.4% were 15 days or more, 22 hours or more on average. So that got us to the 41 to 48,000 as of now, as reported by the people who run prisons. If you turn the thick data book, and this gives you a percentage of people, it tells you something by the states that are reporting. Here, I just want to underscore. We didn't hear from Florida this time, or Missouri, or some states. So the states that are the highest percentages are the states that told us. There may be states that are jurisdictions that are even higher yet. And you can see that it goes from over 14% of a population on a given day to less. And the good news is that over the course of doing this, over the last decade, many people, including some people who run prison systems, want there to be less or no solitary confinement. And so there are some systems that describe themselves as using little or none. If you go to the next page, what you'll see is that there are more than 4,000, 5,000 people who are there for a year or more. And that's just reported, and that's just from 34 places. So we're looking at some people, and famously Albert Woodfox, in a book called Solitary, he was in Angola for more than 40 years in solitary confinement, and a brilliant and resilient and insightful accounter of his own survival and the need for change. If you turn to the next, obviously we look.
Before we turn,
Sure.
We had somebody raise their hand, Lily, and I'm asking her if she has a question before we go on.
I'm sorry, that was in error. I didn't realize my hand was up.
No problem.
Okay,
All right.
No problem.
I didn't want to go on.
Okay.
All right, thank you.
I'm going to try to flash by a few more points because we want to have time for conversation. So just, of course, it varies by gender, and there's a much higher percent of people in isolation in men's prisons than women's prisons. The next slide tells you that it also, that in terms of people, the prisons, when we asked them in summer of 21, said no one who was pregnant was in restrictive housing. Is what is this umbrella for ADSEG and SHU and special and protection and all these things. It's just 22 hours or more, 15 days or more. The jurisdictions on transgender did tell us, and this would be under a heading often called protective, although it's not a good place and it's not harm preventing, that they reported transgender people held close to 300. If we move to the next, in terms of race and ethnicity, we did ask about racial variation. There is some with peoples of color more. Men's prisons, if you turn to the women's prisons, there is a dramatic difference between Black women are disproportionately held in isolation as compared to white women. If we look through this, there's lots of data. Going next to serious mental illness, this shows you There is no universal definition being currently used across 50 jurisdictions or 51 about how you define mental illness. And if you define it more capaciously, and if you say people with that can't be in isolation, that might be good. We have a big appendix. What we know is that under their own definitions, a few thousand people were being held who were themselves described by the system they were in as having SMI, serious mental illness. Coming to the next, on staffing. This is a terrible place to be, not only if you are incarcerated, but also if you are incarcerating. And there's a wonderful website from the University of California, San Francisco called Amend. And Amend is working on the issue of how harmful incarceration is for staff who have higher blood pressure and more suicide and a variety of other problems. So the question is whether there should be special training for people dealing with restrictive or isolation. And some jurisdictions call for training on mental health or de-escalation techniques or the like. And some are trying to rotate people because it's a bad assignment. It's a bad for everybody in the system. Moving to the next, we tried to look at numbers over time because we asked 5 times total, 2013 to 2021. And basically, when we first were investigating this, the best estimate, and this is an estimate and it comes from the people who run prisons, it's not otherwise verified, 80 to 100,000 people at least were in isolation. And now we're down to somewhere in the 40s to 50s to 60s, again, as self-reported. And you can see that I think part of the reasons, there are a variety of reasons. If you go to the next page, you'll see by percentage of the prison population. You all know that in COVID, there was some decline in the numbers of prosecutions and trials, and hence in the number of incarcerated people. So what is driving any decrease at all? One is fewer people incarcerated. Another is some jurisdictions and some people and some lawsuits and some legislation says, stop, don't use this or use this less. And so there's some of that. And so the question is, what could be the drivers to turn it down lower than it is now? And there are clearly concerns from correctional officials who once championed isolation as a good thing to do to manage prisons, and it rises with prison population starting in the 1980s. We're looking at many people running prisons saying this is not a good thing. We've got to figure out how to unravel it. Next slide tells you that the state and a little bit the feds, as a legislative matter, have started to look at this. When we first started, there was basically no legislation regulating solitary confinement. Starting in 2018, you started seeing a lot of action with many jurisdictions considering, some enacting provisions and some pending bills, and then moving to the next 2022 interval. Yet more states in the mix and more things that were pending or enacted. And for those of you who are in Connecticut, we have something called the PROTECT Act. For those of you in New York, high profile, the HALT Act. So there have been enacted bills to limit, and then there's a question about implementation and how they limit and definition. Turning to the next, just a flag for you. Some of the bills are addressed to subpopulations. Don't put kids in, don't put pregnant people in, don't put people with serious mental illness in. Some are general, like Massachusetts and a few other states that say limit or after 60 days provide programming. So there are different forms of regulation in place. The question about compliance and actualization is yet another question. And if you go to the next, several of the pieces of legislation require reporting by, here's Michigan, Minnesota, Nebraska, New Mexico, Virginia. How many people are in? What do you know? What were the reasons they're in? So there is literature to be mined with energy. And then the next, which is from our last report, this is news because jurisdictions told us in the summer of 21, they told us that they weren't, some of them were saying, we don't have anybody 15 days or more, 22 on average. 3 jurisdictions. 2 said under 10 people. Some said, 10 said none in women's. Some said we're changing our policies. So on one measure of formal change, there is descriptions that the use of this in some jurisdictions is going down. The question is, what's the lived experience for the people inside? Is it some people call it near solitary, I'm there for 21.5 hours or 20 hours, or is it really a substantial change? And North Dakota gets should be a shout out for being at the forefront of trying to make for substantial change in limiting and stopping profound isolation. The next slide is a reminder. This is from Brown v. Plata, the Supreme Court decision on hyperdensity in the California prison system, that the bizarreness of our facilities is we have hyperdensity, which has a host of its illnesses and violence associated with it, and hyper-isolation, which has a host of violence and illness, and they are interlocking practices of disability that are here. And then the last slide, a little bit more news. As of the end of last month, the Lyman Center at Yale, with the help of the Oscar M. Rubenhausen Fund and Yale Law School, launched a website called Seeing Solitary, which is just out. Please visit and give us input into how to make it better and more useful. What we realized I meant to have with me, I have this many volumes of all those things I just told you, which are dense and hard to read and boringly detailed and try to be explanatory. So we worked on developing a website that is jurisdiction specific legislation, interactive, to enable more access to this. And for any of you who watched John Oliver on April 1st, he had a 20-minute segment. He invoked this and many other work. The really good news is that Vera, Unlock the Box, ACLU National Prison Project, you all, there are many, many organizations currently engaged in revisiting the visit of seeing solitary. Of course, you can't see solitary this way. You can only glimpse a teeny bit of what it must be like to be locked in cell and how oppressive it is. So this is the overview. We can stop the PowerPoints and we have time for discussion, comments, questions, suggestions, corrections now. So we can end web and look at each other if we can. So
Jackie put a question forward. So we heard a lot about the reduction of the use of solitary, but how much confidence can we really have in the numbers as we understand them to be?
I think it's twofold. I think, first of all, we should always be worried on self-reports. And also remember, it's the slippery definition. So maybe they're really, I believe there are probably fewer people than there were a decade ago, 22 hours or more. The question of the driver, how many of them are 21.5? And that is yet another question. And the other is, what are the drivers of the change? But I think the other, it's important, I think, and worth appreciating that 15, 20 years ago, there wasn't the Stop Solitary, See Solitary, Unlock the Box movement. It was awful. There were people in solitary seeking its end. There were a few cases. There wasn't legislation, and there weren't correctional leaders standing up to say, I'm an abolitionist on this practice. So when I look at the people on the screen, I'm looking at the idea that the collective action from people who are incarcerated, their families who have been tremendous advocates, and their communities, coupled with some law, some legislation, some executive action, don't forget the governors here, and as well as legislatures, have shifted to a view that is fairly widespread, that it's not good to do this. So the old view was, hey, we're doing this, see, we're keeping you safe. Now there is arguments from safety, which I don't think are well-founded, but there is also a real sense that this isn't a good thing to do. And that's a deeper and widening sense than there was. And hopefully, coming back to Jackie, how you can get real change. But let me just add that every person I've met who runs a prison system has said that there would be one or two people who will do grievous harm. And it may be, and mental health professionals will also say, risk of harm to self or others. I want to distinguish what Stuart Grassian, a great psychiatrist, teaches us all. Separation doesn't have to be degradation. even segregation as in some degree of isolation from general population. Doesn't have to be windowless. It doesn't have to be with limited access to showers and activity. So you want to separate out for the very few people who are unable to be safely interacting with others, what are the management practices that are not our current solitary confinement?
So I'm going to actually kind of mix some questions and some thoughts that I just had. So one of the questions specifically asks, what do you believe is the most productive approach for ending solitary confinement? Ask another way, what can we be doing? And then Jackie also asks, and if there is change happening, what can we do to push the trend line? And I was kind of thinking along the same is that, like, and you mentioned it just now, when people talk about safety, right? It seems like we will get to some type of progress when it comes to the criminal legal system. And then one thing happens and they're like, nope, we can't continue with this progress because it's a safety issue, right? So, like when people were being released from jail during pandemic, is like one person messes up. See, we can't release people early because they're going to mess up. So what can we do to have a conversation outside of the context of academia or even in settings like this to talk to people and say, look, this is a good thing. We don't want people locked away. This is a humanitarian issue. Like, what do you think that we can be doing individually to help push the agenda forward as much as we can?
The intersection between law and politics is vivid in the punishment space. And so the question about engaging as the materials I gave on legislation, engaging state and federal legislators to be clear that neither in their name nor their constituents' name do we want this form of punishment. And here I don't think I'm being academic, but I do want to remind that there are a bunch of punishments that governments used to do that were repellent, but are now seen as clearly like we don't brand people anymore. Mm-hmm. And in this large book I'm almost finished with, the state of Arkansas whipped people in the 1960s. And 3 federal judges said that doesn't violate the 8th Amendment as long as it's not too arbitrary and it's limited to 10 lashes at a time. And then in 1968, Judge Harry Blackmun, sitting as an 8th Circuit judge before going up, wrote for the panel, you can't whip. We are looking for the many Judge Blackmans and the many legislators and the many prison directors who say we can't do this form of profound isolation.
You touched a little bit about like transgender individuals being held in solitary, and even in the John Oliver special, they talked about they're just calling it something else: protective custody, isolation. They're doing things in order to say, well, we're not really putting people in solitary. We're doing this for safety concerns, especially with the transgender population. I know I've seen it in local jails where they're saying, well, we need to put them by themselves to keep them safe. What are the arguments against that? There has to be some alternative than putting somebody in solitary by a different name. Yeah.
So the floor is that floor, pun intended somewhat, the floor is that nobody should be in a tiny space. We learned from Albert Woodfox that he thought his eyeballs, he was stopping to be able to see distance because he never was in anything for which there was able to be distance. And he tried to do eyeball exercises. He was brilliant in trying to combat the disability. So it is so bizarre to put someone in a 4x7 or 7x5 or whatever your numbers are space for extended periods of time and limit their human movement. People move when they sleep. And so to the extent we can help people see how unnatural, it isn't the same as saying we're keeping you safe, we're doing something incredibly disabling. Then the question is, if you are going to be unsafe because you are in detention, how does the detaining authority keep you safe? Not by frosting your windows and not letting you see natural light, not by shoving food in and out of your cell in a 20-minute span. Or I think Jackie was saying before this call, JoEllyn, that people could have been missing taking a shower because they weren't awake at the moment the door clicked. So there's a ways to limit interpersonal violence through separation that doesn't have the entailments of the forms of isolation. And the idea that this is normal or typical, and in prison, nothing is normal or typical except if we make it normal or typical. We built prisons. They didn't exist in the 1600s in the way they do now. So the question is, what are the things that you see as intolerable? And I do flash to other forms of bread and water, statutory punishment, many of the states that are on this. Then someone said, wait a minute, we can't do that anymore. Not somebody. People said, I'm starving, I'm losing weight, it's terrible. The Holocaust happened, the human rights emerged, various forms of equality movements. People said, wait a minute, you can't starve people as a form of punishment. People used to starve as a form of punishment. So we have to shift the frame of what's licit for punishment, which is how I come back to either anti-ruination, respecting equality. It's expensive, it's labor intensive. And also I should add, I can appreciate that people who say, where is the society supporting or helping me? I didn't do anything wrong. How come you're helping them and not me? And the answer is we need to help. We're interrelated. So the idea that I'm giving you decent food and healthcare because I'm incarcerating you, you're stuck there, so you don't have any choice. But of course, I should also be providing that for people who need it on the streets.
You mentioned North Dakota taking a shift in basically making real action. What do you think caused that?
In North Dakota and a few other jurisdictions, there were incredibly thoughtful leaders of the prison system who saw the harms of isolation. There was an op-ed by a man named Rick Ramish who ran Colorado, that he had his system lock himself anonymously into cells. It was published in the New York Times, maybe 2017, 2016. And he said he found it incredibly disabling within short order and became committed to ending that. He didn't want to do that to other people. So a series of people who run corrections have seen the harms of it. And so sometimes it comes from the executive branch, i.e. governors, appointees of corrections directors. Sometimes it's interactive with both litigation and legislation. And it is generated, coming back to your question, by social political movements that say, we got to move this off the screen of what's licit in punishment.
Okay, I just want to make sure everybody who's on knows that they can either raise their hand or interact or put it in a chat to ask any questions that they may have, so that I know all of us are probably taking in all the information and trying to figure out where we're going with it or what they thought. So just to give everybody, let you know that we like to hear your input.
Well, just one thing to flag when you were asking, you as criminal defense lawyers, what are the claims that you're raising and what are the facts that you're putting in the record about the ways in which the people you represent are being held? And how much are you able to deal with conditions, jail and prison, as well as individual cases? But in terms of building the record, there's a vast amount of record building that is to which you all are key.
Okay. Another question on record building. When we talk about like keeping numbers, right, and self-reporting, is there something else that should be done? Should we push in our legislators or pushing for regulations we made that say, hey, if somebody's being put into solitary, this needs to be reported? Should we engage ombudsman offices to make sure that these numbers are correct? Because obviously it's self-reporting, and because there's some pushback of it, who's to say that people are under-reporting so that it looks like the numbers are skewing in the right direction? So should we be pushing legislators to say, hey, look, we need to have some type of specific regulatory requirements into how this is reported, not just when somebody asks you about it, but regularly on a period of time. If somebody goes into solitary, why they're going into solitary, the reason, how it's being kept, that is accessible to another resource besides outside of the prisons or jails.
Oh, I mean, there are now 24 statutes, and the question about both how to get them and how to get them as good as they can be, and then how do you implement them is all out there. But the idea, one is this actually goes back in Wilkinson v. Austin in 2005, the district court judge had said, you shouldn't be able to put anybody in solitary if it isn't a Class B felony. So the first step is, inside every prison is a mini criminal code. What are the grounds for what forms of punishment and what are the punishments? And so one is, if you can take away as a basis for isolation being obnoxious in the eyes of a staffer, that would be one way. So one is, what are the bases? Two is, who makes the decision? Should it take the director of the prison system or 2 or 3 people? And how often is that decision made? Once, twice, every 6 months, or every other day, or every day? Does this person need to get in? And coming back to North Dakota, their model was, the day that person goes in is the plan for how that person gets out. So you see this as something that is a very abbreviated. Some places, Colorado has a 15-day cap. You can abbreviate it, limit it. You raise the question, mentally ill people, what a terrible thing to do to someone who is ill, or to make someone ill. And so you say, this is not how health professionals would ever treat a person with these kinds of challenges. So if you start with, what are the grounds? Who are the decision makers? What are the conditions when you're in? What's the exit? And what do we know about the numbers? And what are the golden key ready access for people to check both the nature of the cells, the level of activity, how food is served, whether you get or don't get access to programming of any kind, how much fresh air. Senator Durbin held hearings in Congress in 2013, 2014, or 12 around this, and had one person who testified said, who had been wrongly convicted and was then at liberty, said that he had been, I believe, in Texas and hadn't seen the sun for a decade or so, or 10 years. So you can see that there's just a vast amount to step by step, and the people who you represent have important bases for information to see how to see where the harms are. Testimony in Pennsylvania held hearings the summer before last, and there was a testimony that a man who is a psychologist was in the federal military system in isolation, and he talked about how he still eats quickly because food came in and out. So it's the breakdown to each component part and learning about it, and then figuring out how to stop the parts that are harmful.
I have a couple questions that came up about litigation.
Sure.
One is, has anyone ever had a success in raising human rights standards to end pervasive use of solitary confinement?
Well, as you probably all know, the US Supreme Court is a skeptic on the role of non-US law, at least some members of the court. But first of all, I should do a shout out for state courts, because many state courts not only have different text, a few say prisoners are supposed to get rehabilitated, see Alaska, for example. So there's different constitutional text, and then there's different constitutional opportunities depending on the state in terms of litigation. On the federal side, there are important major decisions and or settlements. Ashker is the 9th Circuit case that involves Pelican Bay. That is a major, there's a moving, the people who were in Pelican went on a hunger strike. There's a big New York Times Magazine story, 2014, 2015, and then there's litigation. And after the litigation, there became a big settlement that's gone up and down to the 9th Circuit, more than one would have wanted, but there is, and its implementation is contested. Peoples is the name of the case in New York that Judge Shira Schindler was the federal district court judge on, that was then in a consent decree. And then in Porter v. Clark is the 4th Circuit decision about solitary confinement in Virginia's death row settings. So there are a series of decisions, and then there's some actually under ADA, disability rights advocates have brought cases for people with special challenges. So if I'm mapping the legal landscape, being lawyers here for the moment, step one is substantive Eighth Amendment, sometimes key to Estelle v. Gamble and deliberate indifference to known medical needs. Step two is Eighth Amendment broader, which echoes your human rights of this is unnecessarily cruel. There are other parts of the Eighth Amendment. Step three, both for people in pretrial and in this, is a form of a kind of substantive due process. These are not ways you can hold people. And then step four is procedural due process. You can only do this if. So that's sort of in the litigation, but that's federal focus. There's state, which can have a wider range of options. And the National Prison Project, among other litigating units, have been very involved in trying to figure out both federal and state. Now, the question about and the role of settlements in coming to agreements, and the role of disability groups formed under federal statutes for protection of disability, and the role of the U.S. Department of Justice and its Civil Rights of Institutionalized Persons Act, CRIPA unit, is also a resource to be looking at.
And one, I think maybe as we're getting close to that 3 o'clock hour, one last question. Are you aware of any court opinions or at least arguments in a particular case that supported a downward departure due to pretrial solitary confinement?
Oh, that's a great question, and I wish I knew the answer to it. There are, I guess I should mention, there's one case that may be helpful. Judge Myron Thompson, sitting in the district in Montgomery in Alabama, has a case whose name I'm blocking on, that a man who had substance abuse couldn't be sent, he wasn't ready to sentence him till he had a medical workup to see if he was able to be sentenced. So that's tangential to it. But, and then I guess there's some, there's a law review article by Skylar Albertson, who'd been a fellow at the Lyman Center and a Lyman fellow, about grounds for compassionate release and grounds for extra injury. There's a body of literature coming off of COVID that says the incarceration was so disabling, you should alter the length of my sentence. So it's not the same as a downward departure directly for it, but it's got the idea. There's a way to stack some of those arguments to say the conditions of confinement need to be factored in to thinking about the form of sentence. When COVID was very present, I ended up doing declarations at a variety of places about how COVID took a legal sentence and made it unlawful because you hadn't been sentenced to illness, you'd been sentenced to 5 years. And there's in federal habeas, there's something called enlargement. You can enlarge the custody to home or to a hospital as a part of federal habeas, and then in some state courts under state kind of writ remedies. So I ended up being a more active litigation expert than I had been for a while in talking about the remedial capacity. You didn't have to let somebody out to change the conditions of their custody as a kind of almost preliminary remedy, temporary remedy, because it was in theory temporary, that the place was so lethal. So there's more. Your question is about what you all as criminal defense lawyers can do in the sentencing space to both develop records and also new arguments about how conditions themselves should be a factor in thinking about the length of sentence. And Skylar Albertson's article is one of, I'm sure, several that try to look at conditions as a factor. And some of it has been informed, sadly, by COVID.
All right. So I'm going to kind of ask, I guess, one kind of catch-all last question, right? So when I'm in spaces like this, when I'm in decarceration committees, I become optimistic. Like, we're going to change this system. We are going to break things down. We are going to abolish prison systems, we are going to just, we're going to be interrupters, right? So we're in this great space and we are having great conversations. And then sometimes I go into the courtroom, probably like many of my other colleagues, and be like, okay, maybe I'm just too optimistic. Like maybe we're not, like as much as we want to, is the world really ready for what we're trying to bring to this? And although we see the decline in solitary, are you optimistic that we are really interrupting the system and that we are able to really make these widespread changes that we want to do? Like I said, when I'm in my NACDL bubble, I feel the love. And then I go out of my NACDL bubble, I'm like, okay, maybe it's not me. Maybe the world's not ready for what we're trying to bring to it. So are you optimistic? Do you think that we are really, and I don't say that we're making change. I know we're making individual change every day, but do you think that we're headed in the right direction and that we are really getting people to really see that the system, the criminal legal system, is not just?
So I'm modestly optimistic from a baseline. When first begun more than a decade ago, or you go back to 2005 and you read Justice Kennedy saying, oh, this is how we have to deal. And then in 2015, he says in a case called Davis versus Ayala, he's concurring and he's denying habeas, but he says, gee, judges should be telling people they're going to sentence them to go mad because they're going to be in solitary. So that's one example that over the last 20 years, people who thought this was okay to do have had second thoughts or more. And the state legislation and a little bit of federal legislation, a little bit in the First Steps Act, is a marker of political will to at least question the use of this, as well as try to ramp some of it down. There's the implementation that is phenomenally challenging. So I kept saying, here's the formal level, what's happening in people's lives. And the stickiness of solitary is that it is deeply related to the isolation of prisons. So if you can lessen the isolation of prisons, you lessen the use of solitary. But I think you have grounds to see that a wider group of people have come to say, this is a noxious practice, who hadn't said it was noxious before.
That's great. Jackie, I'm going to bring you back on to see if anything else you want to add to our discussion.
Oh my goodness, I have 1,000 questions and comments. I think 1 hour is just not enough for such an important topic, but I do want to thank you both, but thank you, Professor Resnik, for such an enlightening and robust discussion on this urgent issue. I'll take, a cautious optimism, but I certainly agree that I think it's sunlight that we need. It seems, when I listen to this kind of a discussion, it seems like you said, JoEllyn, self-evident. I mean, I think anyone who wants what's best for their own children would have to agree that doing no harm would have to be the first goal of a correctional system. And I love the sort of anti-ruination principle that is at the heart of Professor Resnik's work. I'm grateful to both of you. Thank you all for attending.
Let me end on the ask. Please visit Seeing Solitary and tell us what to add, change, fix. So we, on your collective action, it's out there. It's literally just out there. And it is so a work in progress. So please help us make it more useful to you. And JoEllyn, your comment about how to deal, we don't have an entry for using solitary for downward sentencing departures. How do we get that line of cases going? Mm-hmm. Question back to you.
Yeah. Right. And the audience here is full of fantastic litigators who have the ability to drive that forward, I think. And so that gives me optimism as well. And yes, Seeing Solitary website, it's almost a sneak peek, brand new, and we're really grateful to have that. So we're going to share that as well. It'll be, I think it's on the chat, but we are also going to share it with the attendees here and in the future. So, I'm hoping that this drives more conversation. I'm very grateful to Professor Resnik and JoEllyn for such an enlightening and robust discussion. Very, very, there we go. We've got the Seeing Solitary in the chat, and I encourage everyone to go check that out and to contribute to it. So thank you all for being here, Dr. Resnik, or Professor Resnik and JoEllyn.
Thank you. Glad to be a participant, and thank you and Vanessa and for all of your JoEllyn and JoEllyn's leadership in generating these conversations.
I just want to say thank you all so much. It was an excellent, excellent program. And I did put the link in the chat to register for the next in the series, and everyone who registered for this will also get an email, and we'll continue to promote it.
Thank you.
All right, we got some work to do.
Yes. Have a good afternoon, everyone, or morning for those on the West Coast.
Thank you so much, everyone.